Paano nga ba naging batas ang batas? Ito ang topic na pag-uusapan natin sa araw na ito. Pero bago natin pag-usapan ang topic na ito, panoorin niyo muna ito. Alam naman natin na ang ating bansang Pilipinas ay isa sa mga bansa na napakaraming batas. Pero paano po ba ito ginawa? Sino po ba ang gumagawa nito? Yan ang mga katanungan na ating bigyang linaw sa videong ito. Kaya panoorin nyo ang videong ito hanggang sa huli. Pero bago ko po sasagutin ang mga katanungan na yon, let me share with you some fundamentals para mas maintindihan ninyo ng lubos ang proseso ng paggawa ng batas.
The main sources of Philippine laws are the following: the Constitution, statutes, treaties and conventions, judicial decisions, and customary laws.
Those are the sources of laws in the Philippines. Now, let me explain to you one by one those sources of laws. And here it is.
Statutes are the following: Acts of Congress, municipal charters, municipal legislations, court rules, administrative rules and orders, legislative rules, and last but not least, presidential issuances.
Yun po ang statutes. Pag sinasabi nating statutes, ito po yung mga batas na ipinasa ng Kongreso. Ito po yung ordinansa ng ating local government units, mga administrative rules, presidential issuances, and all other rules and regulations that have force and effect of law. So those constitute our statutes. The other one is treaties and conventions.
Section 2 of Article 2 of the 1987 Constitution states, "The Philippines renounces war as an instrument of national policy, adopts the generally accepted principle of international law as part of the law of the land."
That principle in our Constitution is the reason why we consider international laws as part of the laws in the Philippines. Ano ba itong treaty? Ang treaty ay kasunduan ng dalawang bansa, and this agreement is binding between them unless it is withdrawn, and the parties are expected to comply with it in good faith. Ang halimbawa nito ay itong Mutual Defense Treaty between the Philippines and USA. At ano naman po itong conventions? Ang conventions ay ito po yung rules of conduct ukol sa isang subject na binubuo ng mga bansa. Ang example po ng convention ay ang UNCLOS or United Nations Convention of the Laws of the Sea. Ito yung nagde-define kung ano ang territorial waters, contiguous zones, exclusive economic zones, and innocent passage at iba pa. And another source of laws in the Philippines is judicial decisions.
According to Article 8 of the Civil Code of the Philippines, judicial decisions applying or interpreting the laws or the Constitution shall form part of the legal system of the Philippines.
Itong judicial decisions ay yung tinatawag namin sa legal parlance na jurisprudence. May mga principle of laws na hindi naman nakikita or hindi naman nakasulat sa batas, pero ginagamit ng Supreme Court sa kanilang mga desisyon. Example nito ay ang doctrine of last clear chance. Ano po ba itong doctrine of last clear chance? Saan po ba ito makikita? Itong doctrine of last clear chance ay hindi natin makikita sa kahit anumang batas na meron tayo dito sa Pilipinas. Ito po ay makikita lamang natin sa mga desisyon ng Supreme Court or sa mga jurisprudence. So, kahit hindi ito nakikita sa ating mga batas, ngunit ginagamit ito ng korte sa pag-resolve ng mga cases ng accident or vehicular accident. So, simple lang po ang principle na ito. Kung sino yung may chance na umiwas para madisgrasya, para magkaroon ng disgrasya ang dalawang sasakyan, kahit hindi niya po kasalanan ay posibleng magiging liable po yon. Magiging liable po siya. So, yun po ang doctrine of last clear chance. At sasabihin ko po ulit sa inyo, hindi po yun nakalagay or hindi po yan nakasulat sa kahit anumang batas na meron tayo dito sa Pilipinas. The other source of laws in the Philippines is the Islamic laws.
The primary sources of Muslim law, or Sharia, are the Quran, Sunnah, Ijma, and Qiyas.
Dito sa Pilipinas, meron tayong PD 1083. Ano po itong PD 1083? Ito po yung Code of Muslim Personal Laws of the Philippines. And under this law, there is creation of Sharia courts. And these Sharia courts are part of our judicial system. So the decisions of these courts or the Sharia courts are appealable to the higher courts. And in resolving cases before the Sharia court, the court may use the provisions of PD 1083 and other related Islamic laws. The other source of Philippine laws is customary law.
We have a principle in our Constitution which states that the state shall recognize, respect, and protect the rights of indigenous cultural communities to preserve and develop their cultures, traditions, and institutions.
Customs and traditions of indigenous peoples in the Philippines are respected. As a matter of fact, there are tribes that have their own way of settling disputes, and this is respected. And also, there are marriages solemnized pursuant to customs and traditions of a specific tribe, and this marriage is considered valid by our law. The last but not the least source of laws in the Philippines is the Constitution. What we have in the Philippines right now is the 1987 Constitution of the Republic of the Philippines. What it is?
Constitution is defined as the fundamental and supreme law of the land.
Para mas maintindihan natin kung ano itong Constitution, magbigay ako ng isang practical na halimbawa. So, itong halimbawa na ito ay napaka-practical naman talaga. So, meron lang akong tanong. Sino po ba dito ang mga parents na? Taas lang po ang mga kamay. Walang nagtaas. Sino po ba ang hindi pa parents or hindi pa nagiging parent? Itaas ang mga paa. Alright, so wala pa rin akong nakikita. Of course, obviously. Alright, so sa bahay natin, ang ating parents ay gustong magiging orderly, peaceful, at higit sa lahat, gusto nila na maging mabuti tayong mga bata. Kaya sa bahay, may batas. Bawal lumabas o bawal lumabas. Pero pag sinabing joke. Yung batas sa bahay natin, yun yung classic example ng Constitution. Kasi dapat lahat ng ginagawa natin at mga pag-uugali natin sa ating bahay or sa labas ng ating bahay ay naaayon dapat sa rules ng ating parents sa ating bahay. Ang ating mga parents ay nagde-delegate sa atin ng mga gawaing bahay tulad ng si Juan ay mag-iigib ng tubig, si Pedro ang magluluto, si Pedra or si Petra ang maghuhugas ng pinggan. So bawat isa sa inyo na magkakapatid ay mayroong task sa inyong bahay, at yan po ay part ng rules and regulations na ini-impose ng ating mga parents sa atin. Yan po din ang Constitution. Meron siyang mga ini-impose na mga rules of conduct, na mga functions ng bawat departamento ng ating pamahala. At yun exactly ang Constitution. Siya ang nagtatakda kung ano ang functions ng bawat sangay ng gobyerno. Siya ang nagtatakda kung ano ang bawal at dapat. Lahat ng ginawa or lahat ng gagawin ng ating mga sangay ng pamahalaan na hindi ayon o salungat sa kaniyang itinakda ay walang bisa. Magiging null and void if it is not consistent with the provision of the Constitution. So those are the sources of laws in the Philippines. Pero ang tatalakayin natin sa araw na ito ay itong statutes, particularly Legislative Act. Bakit po ba mag-focus tayo dito sa Legislative Act? Mag-focus tayo sa Legislative Act kasi ito yung batas na nationwide ang effect as compared with the other statutes. Ang local ordinance kasi ay effective lamang sa specific locality. Pero ang batas na ipinasa ng Kongreso or ng ating legislative department ay effective sa buong Pilipinas. Kaya Legislative Act ang ating focus sa ating topic sa araw na ito. Ayon sa ating saligang batas or constitution, meron tayong tatlong sangay ng gobyerno or three branches of the government. Ito ay ang executive branch, legislative, and judiciary. These three branches of the government have separate powers delegated by the Constitution. The legislative branch has the power to make, repeal, or amend laws. The executive branch is given the power to execute the laws, and the judiciary has the power to resolve justiciable issues or controversies by applying the law. This is what we call separation of powers. Since the legislative power is vested by the Constitution with Congress, it is Congress who can make laws, amend or repeal them. Our Congress is composed of two houses. One is the House of Representatives and two is the Senate. The House of Representatives is composed of congressmen elected by the electorate of their respective legislative districts, while the Senate is composed of the 24 senators elected by the electorates at large. As a general rule, legislative power cannot be delegated without violating the principle of non-delegation of legislative power under our Constitution. This means that what has been delegated cannot be delegated further. However, our Constitution permitted delegation of legislative power in the following instances.
Legislative power may be delegated to the President by giving him or her emergency powers in case of war or other national emergency for a limited period and subject to such restrictions as Congress may provide, to exercise powers necessary and proper to carry out a declared national policy, unless sooner withdrawn by a resolution of the Congress. Such powers shall cease upon the next adjournment thereof. The Congress may by law authorize the President to fix within a specified limits and subject to such limitations and restrictions as it may impose tariffs rates, import and export quotas, tonnage and wharfage dues, and other duties or imposed within the framework of the National Development Program of the government. Other permissive delegation is delegation to the local governments. The reason behind this delegation is because the local government is deemed to know better the needs of the people therein. Another permissive delegation of power is the delegation of rule-making power to administrative bodies. The reason for this is the principle of subordinate legislation. Another permissive delegation of legislative power is the delegation to the people. According to Section 2, Article 17 of the Constitution and Section 32, Article 6, the Congress shall, as early as possible, provide for a system of initiative and referendum and the exceptions therefrom, whereby the people can directly propose and enact laws or approve or reject any act or law or part thereof passed by the Congress of local legislative body after the registration of the petitions thereof, signed by at least 10% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters thereof.
Sa kasalukuyan, ang ating batas ay tinatawag nating Republic Act. So ang title po ng ating mga batas ay sa kasalukuyan ay Republic Act. For example, meron tayong batas na Republic Act number 9262 or the Anti-Violence Against Women and Children's Act of 2004. And there are many more other laws or Republic Acts that we have in the Philippines. Pero bago ito magiging batas or magiging entitled Republic Act, ito po ay nagsisimula sa isang bill. Hindi po bill ng kuryente, hindi po bill ng tubig. Isang bill na nagmula sa Congress, either in the House of Representatives or in Senate. Since ang bill ay nagsisimula sa Congress or sa Kongreso, ano po ba ang proseso sa pagpasa ng bill sa Kongreso? Yang katanungan na yan ay ating bibigyang kasagutan.
Step number 1. The bill is drafted. Any member of Congress, either from the Senate or House of Representatives, who has an idea for a law can draft a bill. These ideas come from the Congress members themselves or from everyday citizens and advocacy groups. The primary Congress member supporting the bill is called the sponsor. The other members who support the bill are called co-sponsors. Step number 2. The bill is introduced. Once the bill is drafted, it must be introduced. If a representative is the sponsor, the bill is introduced in the House. If a senator is the sponsor, the bill is introduced in the Senate. Step number 3. The bill goes to committee. As soon as the bill is introduced, it is referred to a committee. Both the House and the Senate have various committees composed of groups of Congress members who are particularly interested in different topics, such as health and international affairs. When a bill is in the hands of the committee, it is carefully examined and its chances of passage by the entire Congress are determined. The committee may even choose to hold hearings to better understand the implications of the bill. Hearings allow the views of the executive branch, experts, other public officials, and supporters, and opponents of the legislation to be put on the record. If the committee does not act on a bill, the bill is considered to be dead. Step number 4. Subcommittee review of the bill. Subcommittees are organized under committees and have further specialization on a certain topic. Often, committees refer bills to a subcommittee for study and their own hearings. The subcommittee may make changes to the bill and must vote to refer a bill back to the full committee. Step number 5. The committee mark up the bill. When the hearings and subcommittee review are completed, the committee will meet to mark up the bill. They make changes and amendments prior to recommending the bill to the floor. If a committee votes not to report legislation to the full chamber of Congress, the bill dies. If the committee votes in favor of the bill, it is reported to the floor. Step number 6. Voting by the full chamber on the bill. Once the bill reaches the floor, there is additional debate and members of the full chamber vote to approve any amendments. The bill is then passed or defeated by the members voting. Step number 7. Referral of the bill to the other chamber. When the House or Senate passes a bill, it is referred to the other chamber, where it usually follows the same route through committees and finally to the floor. This chamber may approve the bill as received, reject it, ignore it, or change it. Congress may form a conference committee to resolve or reconcile the differences between the House and the Senate versions of a bill. If the conference committee is unable to reach an agreement, the bill dies. If an agreement is reached, the committee members prepare a conference report with recommendations for the final bill. Both the House and the Senate must vote to approve the conference report. Step number 8. The bill goes to the President. After both the House and the Senate have approved a bill in identical form, the bill is sent to the President. If the President approves the bill, it is signed and becomes a law. If the President takes no action for 30 days while Congress is in session, the bill automatically becomes a law. If the President opposes the bill, they may veto the bill. In addition, if no action is taken for 30 days and Congress has already adjourned, there is pocket veto. Pocket veto is not allowed. Step number 9. Overriding a veto. If the President vetoes a bill, Congress may attempt to override the veto. If both the Senate and the House of Representatives pass the bill by 2/3 majority, the President's veto is overruled and the bill becomes a law.
Those are the steps or process of passing a bill into law. However, kung ang bill ay naipasa na bilang batas, maaari pa ba itong maipasawalang bisa? Yes, kahit naipasa na ang batas or ang bill ay naipasa na para maging batas, ay pwede pa rin itong mapawalang bisa in part or in whole or as a whole. Ayon sa ating saligang batas or Constitution, ang Korte Suprema or Supreme Court of the Philippines ay may kapangyarihang i-declare ang isang batas na unconstitutional, therefore null and void or walang bisa. Ito po ay pinahintulutan ng ating saligang batas or Constitution ayon sa principle of checks and balance. Ano po ba ang dapat gawin? Simple lang po ang dapat gawin. Mag-file lang po ng petition sa Supreme Court tulad ng ginawa ng mga petitioners laban sa anti-terrorism law. I hope na marami kayong napupulot or natutunan sa ating talakayan ngayong araw. So thank you very much for sparing your time with me in this video. And please don't forget to subscribe and click the bell button para ma-notify kayo of my upcoming videos. So see you in my next video, and goodbye everyone.